Our speaker tonight, Hume Steyer, is an old friend of mine, a remarkable man who is one of the great estates and trust lawyers in America. He also is a great board member for a number of nonprofits. He served for many years on the board at Open Space Institute and at Storm King Art Center. And he chairs the board at Black Rock Forest, which some of you may know, a great experimental forest in Orange County, which was originally the Dr. Stillman's.
Ernest Stillman.
Dr. Stillman's, and then was taken over by Harvard as an experimental forest. So there are continuous forest experiments going back to the middle of the or late 19th century, which is, and he chairs that board. And so a person of many parts, but he is very interested in art law and intellectual property law, and so he will tell us about a field that in my minimal contact with it has turned out to be one of the most complicated imaginable, and a system of law relating to art and artists' rights that I hope he can clarify somewhere in my mind. Anyway, here.
Thank you, Peter. I hope the light is good here because I have to read my notes. My eyes are not great. Well, thank you for inviting me. First time I've ever been here, and it is a really delightful and charming spot and has a lot of history associated with it. I don't think of myself as a history maker, notwithstanding the lecture series title. And I don't think of myself as an art lawyer either, but I have had interesting collisions with the topic of this evening's speech, which is the moral rights of artists. And the moral rights of artists are rights that are personal to the creator of the art. In most legal regimes that recognize these rights, they can be bequeathed or transferred in other ways, but they are personal to the artist as long as the artist is alive. They're independent of copyrights, which are rights about publication and reproduction and so forth, but related, obviously. And they, importantly, are retained even after the artist has transferred economic ownership of the work of art that he or she created. So, my first encounter with the moral rights of artists came when I was about a fifth-year associate at a major law firm in New York City that I'm no longer affiliated with, but where I am the lawyer for the head of the firm. And I was in the litigation group and the Trusts and Estates group simultaneously. And the firm was engaged by a prominent national charity devoted to the improvement of the physical, intellectual, and moral capacities of children. And this prominent national charity had its headquarters in a estate in sort of north central Westchester County that had started out as the home of some obviously successful New York City financier and had been converted into this headquarters for this big charity. And it was in keeping with arrangements of its type set in a large park-like setting. And this charity would have their annual meeting in the late spring of every year at this headquarters. And they would fall into the habit of designating a affiliated program, of theirs from somewhere around the country as the sort of affiliated program of the year. And being very careful not to tell you what the charity is and so forth, because it's not appropriate for lawyers to do that. but hopefully I can preserve the flavor of it. So they would designate one of their affiliated programs as the program of the year, and they would invite the program officers, local program people who were running it, and some of the kids to come and accept the award over the weekend. And they would also arrange for the program officers and the kids to camp out on the park-like grounds for the weekend. So prior to this particular event, the charity had engaged a really well-reputed artist specializing in what are called sometimes earthworks, outdoor sculptures that participated very closely in the landscape, not quite like the Storm King sculptures, although there's one famous one that I know Peter is smiling about. I'm thinking of the Wayfield. This artist was engaged to build something on the park-like estate, and she did. She had an amusing assumed name for her professional work, and she built it. And the affiliated group came that spring, and they set up their tents in the grounds, and the kids got bored after the tents had all been staked down, and so the program officers said, "So boys and girls, off you go into the park-like grounds and find some kindling. We're going to build a bonfire and roast some wieners and marshmallows." And so they fanned out. They were issued hatchets, and they fanned out on the park-like grounds, and they found the sculpture, which was a rather decoratively assembled group of logs and twigs. And they instantly recognized it for what it was and hacked it down and brought it back. And it was duly burned, and apparently the s'mores were great. But when word reached the artist, she didn't see anything funny in this, and they wrote a letter of, abject apology, and she wrote a letter back saying, "You'll be hearing from my lawyers," which we did. And she sued them. She had sold this object for a six-figure sum. This is a long time ago, but it was an expensive object. She said, "I have been damaged," and the lawyers said, "Our client has been damaged. Her reputation is in tatters. She's an object of ridicule, and you owe us a multiple of the cost of the object in damages." And so this case was staffed by a partner. I was not a partner at that stage of the game, and me. And I was the junior lawyer on the team. But the senior lawyer on the team went to the Serengeti for some kind of a trip, a safari. And when the telephone rang in my office, it was somebody from the national charity saying, "Listen, we tried to reach Alan, your boss, but he's apparently unavailable. So we're calling you. We've been thinking, the board has been thinking about this. We want to talk to you about, what our strategic course of action ought to be." And so I went to the head of the litigation department and I said, "This has happened, and wouldn't you like to accompany me and possibly tell them, what they should be thinking?" And he said, "No, I can't do that. I'm busy. But I'd be happy to give you my views on, how you ought to be thinking about all of this. Tell me the story." I started telling him the story, and I got about 3 cents into it. He put his hand up. He said, "Hume, I don't know anything about torts. I don't know anything about art. I don't know these people. You're a smart guy. They seem to like you. Go talk to them." So I went. And they said, "So we bought this, right? We own it. It's bad that it got hurt, damaged, but it was ours to damage. This case is really pointless, right?" And I said, "Well, first of all, the state of California has a law, a statute, which expressly creates a right in artists whose work is mutilated or damaged in a way that is inconsistent with their reputation or honor, and provided it's a significant work." And there's no argument here that this is a significant work. Look at the price he paid. There's legislation of a similar kind under consideration in New York, which, if it's like the California statute, will only apply to events that occur after the effective date of the legislation. But there's no law that says laws have to be like that. It could be retroactive. And a court of equity in the state of New York would have no difficulty finding a cause of action here because the damage to the reputation is real. And reputations have value, especially if you're an artist. So, no, I disagree with you people. You did pay for it, but that doesn't mean this is a specious lawsuit. So, my partner, Alan, he wasn't my partner in those days, he was my boss, came back and said, so I hear you had a meeting with these people at the big charity. I said, yes, I did, and this is what I told them. He said, Jesus, I would have said they were right when they said this was a specious lawsuit. And I said, that's why you shouldn't go on vacation in the middle of a lawsuit, if that's the way you feel. But, call them up, say what you like. And he did call them up, and they said, Alan, you really shouldn't go on vacation in the middle of a lawsuit, and the boy is right. So it was settled. 4 months later, but before the New York legislation was enacted, and it was enacted, prospective only, an office building not far from our law offices, the ground floor was occupied, and I think some of the upper floors, by the Bank of Tokyo Mitsubishi. And they didn't have a real retail banking business in the United States, but they did have this one retail outlet there were a lot of Japanese people working on Wall Street in those days, for those people. And it had been a bank for a long time, and this was a teller, room for a long time, so it had a real high ceiling and big, a bank of, desks behind a glass wall and so forth for the tellers to sit at. And somebody at the bank decided it would be a great idea to commission a Japanese sculptor to build a sculpture on site in this enormous space. And so this Japanese sculptor came to America, and he welded together a giant inverted pyramid out of shiny metal, aluminum or something, which he suspended point down from the ceiling on 4 invisible wires. So you really couldn't see the wires, and the object appeared to be not just floating in space, but subject to the laws of gravity and probably coming down on your head point first any second. So not surprisingly, perhaps, the customers melted away. Nobody came to the bank. The tellers called in sick. The place was a tomb. And it didn't take long for the managers to figure out what was going on. So that weekend, they got some guy with an acetylene torch to come in and cut it to pieces and get it the hell out of there. And the sculptor sued. And still, the state of the law was basically what it was at the time that I gave my advice. And the sculptor won. So we were very pleased to have settled. Then, the New York state law was passed, and Richard Serra built an enormous Corten steel sculpture called Tilted Arc, which was paid for and installed by the U.S. Government Services Agency, or whatever the hell they call it, in the Federal Plaza in Foley Square in New York City, the FBI building, as we used to call it. And the people who worked in that building hated this sculpture because they had used the big plaza in which it was located to have lunch on sunny days and stuff like that. But there were no sunny days when you were anywhere near Tilted Arc. It was this vast, menacing, ominous object that blocked out all sun. And so the people who worked there didn't like it, and they noisily objected to its presence. And you'll understand the significance of this later in this talk. 15 days after the President of the United States signed legislation enacted by the Congress called the Visual Arts Rights Act, the General Services Administration sent some guys in overalls in to disassemble that, not disassemble it, but flatbed that sculpture out of there. And Sarah sued under VARA, Visual Artists' Rights Act, and lost. And it was deemed to be entirely within the rights of the government which owned the sculpture to move it, because they didn't destroy it. They just moved it. And Sarah noisily, and he knows no other way, objected that it was site-specific. And it was one of the first cases where it was adjudicated, it's not where it is. It has to be, it doesn't have to be preserved where it is. It has to be preserved as it is. So there's the protection against mutilation, modification, or deformity, intentional or otherwise, is not about site-specific art. There are exceptions. All laws have exceptions, but very few. Anyway, I'm getting ahead of myself. That was to explain to you how I came first to encounter the question of the moral rights of artists, because this was a clear case of a right retained by an artist after she sold her work that arose because of the way the work was treated when it was no longer hers. And I now deal with this from two perspectives. I do represent a couple of very famous artists, including the one we were just discussing. But I also more frequently deal with, and I don't do transactional work for these artists. They have lawyers for that. I did, however, talk to them and their lawyers about moral rights, because they're very different in different parts of the world. And these are artists who sell all over the world. And they make contracts. They sell their work for millions of dollars. And they make contracts with the buyers. And they can import these concepts I'm about to discuss into those contracts. And if it's a contract, it's binding, even if the local law wouldn't make it enforceable in the absence of a contract. So I've talked to them about that. But more importantly, I represent a lot of collectors. And these collectors are on the receiving end of contracts that are provided in connection with the purchase of works of art by them from their fancy artist, counterparties. And I do get asked, since these people don't keep local, in-house lawyers to deal with their art contracts, so I get to look at those contracts. And I have seen some doozies, let me tell you. Anyway, I'm not going to say anything about the artists in question, but they know about these provisions. Let there be no doubt, because I really one time I said to the lawyer, he's from Singapore, I said, I can't believe that, and the artist is Japanese. I said to the lawyer from Singapore, I can't believe that your client even knows that you're asking for these things. And he said, we can get her on the phone. I said, let's do that. He did, and she knew everything. She could have taught me. It was something, I am telling you. Anyway, so let's talk, that was supposed to wet your whistle. I will try to find some good stories in the course of illustrating the principles of this law, but you should understand the principles of the law. First of all, it comes from France. And of course, there are two things you know about any French legal regime. First of all, it will be elaborately codified. They love elaborate codification. And second of all, no matter how peculiar, it will be wrapped in the mantle of virtue. So, this is essentially a French regime that goes all the way back to the 19th century. And it is now codified in something called the I'm not going to do the French, although it's a lot of fun to practice. It's called the Intellectual Property Code, or the IP Code. And it contains the following types of provisions, just so these are illustrative. We're going to get a little more detailed in a minute. So, in France, not in America, an artist has an inalienable, non-transferable right to dictate whether and how art is published and exhibited, even after it has been conveyed to a new owner. This is frequently the subject of serious negotiation in those contracts between artist and patron that I was talking about. But there is no such right in America. You have to negotiate for it if you're the artist. In France, you don't have to negotiate for it. And it prevails over the contractual right of others. So, there are a lot of contractual rights that one acquires when one buys something for instance, but there are other people who might also have rights related to this property. But if the artist is unhappy with the way, there might be a lease, for instance. Somebody might have leased the property for exhibition in a certain way, paid good money, but if the artist withdraws it, this is actually called the right of withdrawal, and I forget what the other word is. Repentance. The right of withdrawal. They're French. It's the right of withdrawal and repentance. And if you exercise this right under the French code, you have to pay whoever is damaged by your exercise, but you have an absolute right to exercise it. The only exception to the absolute right is you cannot do it for commercial reasons. You can't take it back because you have a better buyer somewhere else or something like that. You must only do it because you wish to destroy it, because you don't agree with it anymore, or something like that. But the French regard that as an inalienable prerogative of artists. That's all I have to know about that. So then there is, now this is an absolutely core right, not just under the French IP code, but under the American code. All around the world, Mexico, Nigeria famously have this. It's called the right of attribution. And it basically says that an artist has a right, after alienating the property itself, selling the property, to have himself identified as the creator of the work. And in France, of course, there's a statutory obligation that every single copy, image, use of every kind must contain the name of the author. No exceptions. In America, it's really just the original and all copies. There can't be more than 200 copies, or else it doesn't fall within the statute. I'm getting ahead of myself. So you're supposed to be credited with authorship. And you also, in France, have the right to publish anonymously or pseudonymously. I do the pseudonym. There is no such corresponding right under the US regime. But in France, it's a right. Original and all copies and publicity. And in France, you can prevent false attribution. You can't do that in the United States. You can assert your right to accurate attribution. But if somebody says, oh, I made that, your only recourse, basically, is to say, I want every single example of that and every single exhibition of that to clearly state that I made that. But it doesn't necessarily contradict what the other guy's saying. But it's pretty effective. Anyway, that's called the right of attribution. The other big one that everybody knows about, but which is a source of endless dickering in these contracts, is called the right of integrity. And what that means is the artist who has already alienated possession and ownership of the object, nevertheless is entitled to damages, injunction and damages, and fees and costs and all kinds of other things, if the object is deformed, distorted, or mutilated. If in a way under the US statute, which, the words are so strange, is injurious or something to the artist's reputation or his or her honor. Very Victorian. In any case, it is not hard to discern when mutilation is, falls into this category. If, for instance, a bunch of children burn your thing down to make s'mores, that's a good example. Anyway, so it doesn't necessarily, under US law, cover the right to prevent destruction. In the US, the work of art has to be significant for that right. And the reason is very French. In the French mind, distorting or mutilating the work in a way that is damaging to the reputation or honor of the artist is an offense to the artist and a mischaracterization of the artist's soul and artistic intent and accomplishment. Destroying the object just means it doesn't exist anymore. There's no insult there. To the French, what can I say? Who are quick to take offense, Peter. Anyway, I will stop. This is not supposed to be part of this lecture, but I will tell you one of my all-time favorite anecdotes. After Napoleon was finally defeated, the French withdrew their diplomatic legation from London for about a year. And and after this, no more French jokes, I promise. Because I really love the French, and more than they love me. Anyway, in my experience. And I love their food, but I love the people. I really love the people. Anyway, the French withdrew their legation for a year, and then they sent the people, the diplomats back, but there was still pretty frosty relations. And so there was this society hostess in London who imagined that if she had a good dinner party, and she had invited the leaders of the English successful military campaign and the French diplomats to the same party, that they would discover that there's good in all people, and that possibly they had been a little hasty in forming a negative view of the other ones. So she did that, and it was one of those parties where there's a major domo who announces people when they come in, and then they get to walk down the marble steps into the ballroom. So the French were there, and they were standing around drinking champagne, and then the big thumping of the stick, and the major domo intones the Duke and Duchess of Wellington. And the French, who had no idea that Wellington was coming to dinner, turned their backs and refused to watch them as they walked down the marble steps. And the hostess was mortified, and she ran over to the Wellingtons and said how sorry she was, and that she didn't imagine this would ever happen, and which they forgive her and whatnot. And Wellington, who was a very tall man, looked down at her and said, "Please do not," I'm not going to imitate the way they spoke, "please don't disturb yourself, ma'am. I've seen their backs before." Anyway, so no more French jokes, I promise. So, in France, moral rights are inalienable, imprescriptible, can't legislate against them or have judicial findings against them, irrespective of the countervailing considerations, and what does that say? Looks like unrebearable, but that can't be right. I don't know, but whatever it is, you can't do it. So that's France. And I'm going to say at the very, very end that the French system, which is absolutely the source of all of these ideas, and in many cases the source of all of the nuances and subtleties that are interwoven through these laws, have in Europe become the EU law, which is far and away the most progressive, far and away the most widely enforced, and contains, and I will give you this concept because we're still at the sort of conceptual point, it contains a critically important notion, which is vigorously enforced throughout the EU, that artists also have a right of resale royalties. So if an artist sells an object she made for 100, and then the purchaser resells it for 300, then depending on the band of value that it's sold at, the artist gets 5% of the $200 gain. And this can happen as many times as the object trades in the markets. So the artist has a wonderful lifetime royalty and even perpetual royalty from the resale at a profit. The rule doesn't apply if the owner sells for less than he paid. And that's called the right of resale royalties. A particularly withering appellate court decision was written in the United States, thoroughly repudiating that concept. It is not likely, in my personal estimation, which is worth very little, that that concept will be legal in the United States for quite a while to come. But I can tell you, there are a lot of people who want it to be true, and they're not just artists. A lot of people think it's a question of fairness, fundamental fairness. And these are moral rights. So anyway, I think that's the least moral right I've ever heard of. It sounds like a commercial right to me. Anyway, so U.S. moral rights came to being in 1980 in California with the California Art Preservation Act, CAPA. And this was the prototype legislation in the United States. It was in effect at the time that the lawsuit against my national charity was brought, as the artist in question made abundantly clear in her moving papers. And it was not, it had no application in New York. But it lasted until VARA came along. And I'll explain that when I get there, but VARA is a federal law, and it preempted all state laws in the areas that it was legislated, and it's part of the Copyright Act, which also preempts. So the CAPA, the California Art Preservation Act, protected attribution, remember the right of an artist to be recognized and acknowledged as the creator of his or her work, and also integrity, the right not to have your art burned for a weenie roast, but only applied to fine art. Nobody knew what that was, especially in California, where I believe people still don't know what that is. Anyway, the California statute made clear for the first time, and now this is very important in all these statutes, that conservation, if some art needs to be conserved, stabilized, possibly repaired, and you hire a professional conservator to do this and pay him money, if they screw it up and damage the art, it's not a violation of the right of integrity unless it was gross negligence. So it imports this gross negligence concept, and is basically being nice to conservators who mostly are trying their best, but they do drink. Anyway, so CARA is no more because it was superseded by VARA. And other state laws, including New York, which in 1985 enacted the Artists' Authorship Rights Act, AARA. That was after I had my little chat. But I knew it was happening. I was able to tell the client that it was happening, and it would be unclear. It was unclear at the time whether it was going to be only prospective or maybe retroactive. Anyway, that was enacted, but it too was superseded by the preemption of VARA. So VARA was enacted in 1990, but effective in 1991. It adopted the Berne Convention, which was the big European convention that was first set up in 1898 or something, motivated, of course, by the French, but then reenacted in 1988. And they then went around the world saying, won't you join us, won't you join us, won't you join us? And in 1991, the United States did adopt that bare bones moral rights statute. But they, being in America, also wrote it their way. And it protects only the rights of attribution and integrity. And it protects it only for visual art. And it only applies to originals or signed multiples of 200 or fewer. So a mass-produced series will not be protected by VARA. And even photographs must be signed or they're not covered. And it doesn't apply to movies or advertising or periodicals or working papers like, models or diagrams or anything like that, or electronic publications of any kind. It does apply to unfinished work. So if somebody's been working on something and then it is defaced or something, if it's a recognized artist, and I'm coming to the standards in a second, it's going to be protected even though it isn't complete. It does not apply to site-specific art. I talked to you about that. There's a couple of very funny stories about that. One of them was a case called Phillips versus Pembroke Real Estate, where an artist had 27 sculptures installed in a public park in Boston. And the park got tired of them and had them removed. And that is where it was that decision that the First Circuit, which is the appellate court, federal appellate court for New England, said it's not where it is, but as it is, that it needs to be preserved. They really turn a phrase up there. Anyway, And Sarah's another example. And it was removed 15 days after the U.S. adopted the Berne Convention, just to rub it in that Richard is irascible. And then the right of attribution is protected, but not the right to publish anonymously or pseudonymously. Doesn't prevent the use of a name if the work has not been distorted. If the work has been mutilated, you can say, it's not my work. It's been screwed up. I don't want my name on it. But if the work has not been distorted, you have no right to remove your name. That's the distinction in the American law. Does not prevent others from being named as the author, but it does give you the right to insist that you be named as the author. And this is America, so they said if it's promotional material, you got no protections. Anyway, the right of integrity, this is the right to prevent damage. Prevents intentional distortion or mutilation or modification if prejudicial to honor or reputation. That's the American standard. The work has to be of recognized stature, and it prevents destruction by gross negligence in that case. The standards are on page 20 of these materials. I'm not going to read from them. It's too boring, because now I'm going to tell you one of my personal favorite stories relating to moral rights of artists. This is a case called Cohen versus G&M Realty LP. And G&M Realty LP was a development company owned by a man called Gerald Wolkoff, who bought a bunch of abandoned warehouses in the Bronx that had been covered with graffiti for years. And the graffiti was acknowledged to be sort of temporary in that people would paint over it and put their own graffiti up at will, and nobody objected to that. But the graffiti had appeared in many Hollywood movies, as a backdrop for many a runway show. I mean, it was a famous site for highly developed graffiti, which was a very prominent activity in New York in those days. So there was a lawsuit. Wolkoff announced that he was going to tear down the warehouses, thereby destroying the graffiti, and build some nice apartments. And the graffiti artists sued and said, "Vara, vara, vara." And they made a motion for a preliminary injunction, which would have stopped any activity. And the judge said, "No injunction. I'm going to have my decision for you guys pretty soon." And he issued that order. And the next day, Wolkoff got some guys in overalls with whitewash in buckets, and they painted over all the graffiti. Didn't tear the buildings down, because they weren't ready to do that yet, but he destroyed all the graffiti on purpose. And so then the judge wrote his decision. And he said, well, that violates VARA. That was destruction, and deliberate destruction of art. Was the art significant within the meaning of the statute? Yes. Look at all these movies. Look at these runway shows. Look at these photographs and all that stuff. It was clearly culturally significant. And indeed, this expert that was hired by the artists says that it was artistically significant. And I have no reason to doubt it, since this moron developer didn't put on any contrary testimony. So yes, it was significant, and it was destroyed, and that's a violation of VARA. Unfortunately, there's no market for this stuff, so I'm unable to assess damages based on damages, actual damages. Fortunately, there is a statutory penalty for willful destruction in violation of VARA, $150,000 per object. There were 45 artists involved here. 45 times $150,000 is $6,750,000. Please pay at the door. And that was the decision. And it went up on appeal, an almost hysterical appeal from Mr. Wolkoff. And the appeal was denied in I'm not going to quote, but it was pretty funny. The judges said, "Are you fucking kidding?" Sorry, are you kidding? Anyway, and this fine was upheld. And so that is the case of Cohen versus G&M Realty. It's a favorite of mine. Anyway, exceptions for this, right of integrity under the U.S. statute. If the damage is called by the passage of time or the nature of the materials, no luck. Non-negligent conservation, no luck. Mass publications, no luck. This is an important one. If an artist has a work that is integrated into a building, and the building is knocked down or damaged or even modified in such a way that the art is destroyed, then if he consented to that, if the artist consented to it being put into the building, knowing that if the building were modified, that would be it for his art, then the building being demolished or something will not result in a VARA violation. But if the artist did not consent in writing to that happening, and it could have been removed even at great expense and trouble, then you have a VARA violation. So, I'm getting hyper-technical here. Remedies, if it's attribution, then you can only get an injunction. So if it's using the wrong name, you have a right to get an injunction that at all times the correct name will be given for the attribution. But if it's integrity, impounding damages, actual and statutory, profits, costs, fees, money is what you're entitled to under VARA, and plenty of it in many cases. So, as I said, VARA supersedes all other legal and equitable rights concerning attribution and integrity. Your rights can't be transferred, but they can be expressly waived. So these contracts sometimes ask the artist to waive some of these rights, usually in exchange for all kinds of other goodies. And notably, they are unaffected by the sale of the work or any copyright. So you can sell your copyright to the work too, and it doesn't affect your right as an artist to these things. Resale rights, that's what I was alluded to earlier, widely recognized and enforced in Europe. If the sale is if it's less than 3,000 euros in the sale, there is no resale royalty. If it's 3,000 to 5,000 euro sale price, the royalty is 4 to 5%. If it's 3,000 to 50,000. If it's 50,000 to 200,000, it's 3%. If it's 200,000 to 350, it's 1%. 350,000 to 500,000 euros, 0.5%, and anything more than 500,000 euros, 0.25%. So this is real money, and it's an evergreen right. If you've collected royalties before, that doesn't mean you're not entitled to them again on a subsequent sale. I stopped writing at that point, so of course I have nothing further to say. But it's been a pleasure.